My Lord, the Chief Justice, my Lords, the Justices of the Supreme Court, I'm still Mwesigwa Rukutana, Deputy Attorney General, representing the Attorney General, who is present in court, and appearance for all the other parties is still the same. My Lords, we are ready to proceed with today's business, but before we proceed, the respondents have some issues to raise. My Lords, when we appeared before this Honorable Court on the 7th of March 2016, Counsel for the Petitioner, Mr. Asman Basariwa, raised an alarm to your Lordships, alleging that 15 of the petitioner's witnesses had been arrested by the police. Had been arrested by the police and all other security agencies from the petitioner's residence and that they are being detained at Chireka Special Investigation Unit. My Lords, Counsel sought this court's protection for the witnesses. My Lords, in response, my Lord, the Honorable Chief Justice, you ordered the Attorney General to look into the matter with a view of ensuring that if the witnesses were not arrested on lawful charges, they should be released and all protected. Following your Lordship's order, the Attorney General has carried out exhaustive inquiries and has made investigations, and I wish to report to this Honorable Court that the allegations were found to be false unfounded and malicious. Our inquiries have revealed that no one by the names mentioned before this Honorable Court or at all had been arrested from the Honorable Mama Mbabazi's residence or anywhere else and detained at Chireka Special Investigations Unit. My Lords, we communicated our findings of the inquiries this Honorable Court yesterday by our letter. I presume our letter is on record. That was yesterday, but it was received this morning. Our letter attaches a letter from the Inspector General of Police denying the allegations. In that letter, my Lords, we pointed out that we shall be protesting against council's unprofessional conduct. I'm now rising to register our protest. Against this unprofessional unbecoming and malicious behavior of counsel for the petitioner. Needless to point out, my Lords, this is perjury. My Lords will appreciate that this is a very important case, and all local and international media have keen interest in the proceedings. Indeed, the allegations were widely carried by both the local and international media. I watched the footages on CNN, Al Jazeera, and other international media. Yet, my Lords, these allegations were false. Counsel's behavior, therefore, begs for an answer why the petitioner or his counsel should raise such a malicious and false allegations against the Uganda Police Force or the security agencies of this country. One is left wondering what it is they intend to achieve by these allegations. How will these lies assist them, or indeed this court, in the prosecution of this case? My Lord, against that background in mind, yesterday we were served with a copy of a letter addressed to this Honorable Court claiming that the petitioner's lawyer's chambers were broken in two. On the night of 8th March 2016, and that their computers, laptops, documents, and affidavits were stolen. My lords, I don't intend to usurp the role of an investigating officer, but considering the behavior of counsel I've already alluded to, I would not be surprised if the alleged break-in was also a stage-managed inside arrangement or a hoax intended to raise sympathy from this honorable court, from members of the public, or to cover up for some gaps, or just to buy time. Having said that, my lords, it is my prayer that counsel for the petitioner should be prevailed upon to refrain from that unbecoming behavior or should be reprimanded by this honorable court not to engage in unprofessional conduct. As lawyers, we are officials of this court, and our role is to assist the court to reach a fair and just decision. Definitely, we cannot do that by misleading court, by telling lies, by raising false alarms for whatever reason. My Lord?
I think you've made the point.
I have. Much obliged, my lords.
Yes, my lords, I fully associate myself with the submissions of the learned Deputy Attorney General. My lords, when this court sat on Monday, the 7th, it ordered the petitioner to serve the amended petition their affidavit evidence and also the annexures which we have complained about, which were missing from the original petition. And also that same day we were served, first respondent was served with the amended petition, but since then with nothing else. Neither the affidavits nor the annexures that we have been consistently complaining about. My Lords, it is important to note that at paragraph 31 of the original petition, the petitioner stated that the petition was accompanied by his affidavit, together with other affidavits sworn by the deponents, whose names appear in a list attached here to marked A. My Lord, there were no such affidavits accompanying the petition. Neither was there the list referred to. That petition was filed on the 1st of March. To date, those affidavits have not seen the light of day, either for the court or served upon us. My Lords, it is our submission that the petitioner is not serious in the manner he is conducting his petition. And he is even discourteous to the court when he writes in his letter, or his lawyers write, that they shall inform the court on the next course of action. And also it is the court which decides the course of action. So, my Lords, I pray that the petitioner be admonished with his counsel. This is a very serious matter. It involves the nation, and we should see that it is properly conducted. Most of it.
My Lords, I fully associate with what the Land Deputy Attorney General has stated, as well as counsel for the first respondent. In addition, I wish to point out to the court that up to now, the petitioner has not served a copy of the amended petition and the additional affidavit upon the second respondent, and that includes the second respondent's counsel. On 9th March, that's yesterday, we wrote to the registrar of this court drawing his attention to that fact, and a copy was delivered, a copy of the letter was delivered to Michael Akampania and company advocates as directed by this court, that that should be the law firm served on behalf of the petitioner. We have had to rely on photocopies from counsel for the first respondent and third respondent in the interests of time. But we beg and we pray to this court that we should be served. Secondly, at the last hearing before this court, we pointed out that the affidavits which were supposed to be attached to the amended petition were not attached. And I remember this court directed the petitioner serve all the parties with copies of the amended petition and the affidavit in support, the additional affidavit in support, as well as those other affidavits, to use the court's words, before the close of business on Monday afternoon. This was not done, and I believe that time the alleged break-in had not happened. At least there is no allegation of any break-in at Maibach Imperial and Company Advocates. Thirdly, when we last appeared here, the petitioner filed a notice for reduced documents and for inspection of certain documents. Well, let's begin with the first document is the results declaration forms, which each copy is 56 reams. And we believe this court needs at least 616 reams. So we've written to the registrar of this court to find out whether it's really necessary to produce these copies. At the same time, we have invited all the parties, including the petitioner, to come to the second respondent's boardroom on Saturday at 2 p.m. to inspect, because that's the term they used, to inspect the results declaration forms. My Lords, I must also point out that in the petitioner's pleadings, the petition, and the affidavit, the additional affidavit in support, they state that they have their copies. And we believe the purpose of the inspection is to cross-check what is in their copies vis-a-vis what is in the second respondent's records. Regarding the other documents, I wish to go on record that as far as the national summary of the final results is concerned, the district summary tally sheets and the tally sheets of the results per polling station, the 28,000 plus in this country, that information was provided, a soft copy was provided to all the candidates, including the petitioner, on the 23rd of February 2016. The other request on the biometric, we shall be communicating to the petitioner before the end of today about the petitioner's request.
Good morning, my lords. My lords, I have carefully listened to the submission of the learned Attorney General, and I wish to respond as follows, my lords. My lords, when I raised this matter before this honorable court, I had an informal discussion with the learned Attorney General the Honorable Fred Ruhindi outside the court premises. My lords, we shared contacts and he promised to follow up this matter. On that very same day, my lords, at about 1842 hours, the learned Attorney General, Fred Ruhindi, sent me a text message, indeed following up on that matter. Yesterday, my lords, at about 8:55 a.m. in the morning, I rang the Attorney General, the Honorable Fred Ruhindi, notifying him of the break-in of our offices, but also the status of the witnesses. My lords, I wish to appreciate that when I raised this matter, indeed the Attorney General made a follow-up. Those who were arrested were transferred from Chireka, taken to Jinja Police Station and Narutunya Police Station. On Tuesday, my lords, those witnesses of ours were actually released. So, my lords, for me, we are grateful that the Attorney General exercised the greater presence of mind and responsibility when that matter was raised before this honorable court. If that is unprofessional, if it is discourteous, I leave it to court, because in any case, we are not asking for a ruling on that matter. My lords, finally, we have had an opportunity to interact with some of those witnesses who were arrested. We have elicited statements from them. And part of what is contained in those affidavits actually relates to their ordeal, and it will be formally on court record. My lords, that's what I can state in as far as that matter is concerned.
Well, before you sit down, there was a reference to your paragraph 31 to your petition.
Sorry?
Paragraph 31 of your petition, first petition.
My lords, my colleagues will respond to that other aspect.
My lords, I have carefully listened to submissions by my colleagues, and I wish to state that on the night of the 8th of March 2016, the chambers of my colleagues, Wema and Company Advocates, and Yanzi Chiboneka and Baba's Advocates, were broken into by some individuals who were wearing police and military uniforms, and my lords, during the break-in, a number of vital documents which were essential for this case were stolen. My lords, in addition, a number of computers were stolen. My Lord, as a result, we spent the entire day yesterday trying to reassemble the evidence which we consider to be essential for purposes of this court. My Lord, it is therefore, in my view, very unfortunate for someone to state that this was state managed by the petitioner and his legal team, because we have absolutely nothing to gain from such a process. Nevertheless, my lords, we have tried within our means to ensure that we assemble some affidavits, and my colleague will shortly address you on that matter. Lastly, my lords, my learned friend Mr. Dita Simple-Ziza stated before this court that we are being discourteous, we are being serious. My lords, we do not agree. We are indeed very serious with this petition. When we wrote to inform this court and to inform our professional colleagues about the unfortunate incident, my lords, we were being courteous, both to court and our professional colleagues. My lords, we have endeavored to ask the campaign team to reconstitute, in particular, the video recordings which we undertook to supply. Those are mixtures that my learned friend was complaining about. The process is underway, and we are sure that before close of the day, it will be constituted and we will be supplied. That is all I have to say.
But before you sit down, Mr. Akampola, there is still a question you are not answering. You filed your petition on the 1st of March. You had had 10 days within which to prepare your petition and file it. And you filed it on the last day. And in paragraph 31, you stated, I will quote, "The petition is accompanied by the petitioner's affidavit, together with other affidavits sworn by deponents, whose names appear in a list attached hereto and marked A, and more affidavits to be filed later." When we first convened here on Monday the 7th, this issue was raised to you, that the affidavits you are talking about in this petition had not been filed or served. And you undertook to file and write and serve them the same day, by close of the day on Monday. Now that was before this break-in, this is before the people were arrested and so on. You are saying you had affidavits that were supposed to accompany this petition, and you undertook to serve them. Now the question is, where are these affidavits, and why have you not complied with the directive of court?
My lord, on that day we left court quite late. And when we left, we immediately assembled at the chambers of my colleagues. The affidavits that I'm referring to, my lords, were in the chambers of Wema and Kampala. There are over 100 affidavits at that time.
Mr. Akampola, I really am not bothered by how many they were.
Your statement in your petition says these affidavits were accompanying the petition.
Yes.
And we pointed out to you
that actually the petition was not so accompanied, and you undertook to file them that same day and serve. Now you can't start using the excuse of the breaking which happened yesterday. This was three days before. So what is your explanation to this?
My Lord, if I recollect, I instructed one of our colleagues to serve that day. So I'm surprised that they were not served that day. But I did instruct one of my colleagues
You
to
see,
serve.
look, Mr. Kamprula, either you are serious with court or you are not. You are a senior lawyer and you should know what you should do. We can't answer to whom you instructed in your chambers, whether it was a clerk or somebody else. You undertook to court to file these documents. This is a very important petition, isn't it?
It is, my
It's a
Lord.
very important petition, and you are a senior lawyer. You claim in your petition that these affidavits are accompanying your petition. So really, it's not an explanation to the court. You should in fact explain to your petitioner why you are messing up his petition. Because the way, that's what it is.
My Lord, we apologize, but we shall endeavor to ensure that these affairs today.
My Lord, just a short reply to the submission of Council Masarima. I am privy to the informal discussions referred to between Council Masarima and the Honorable Hindi, Attorney General, regarding the allegations. Those informal discussions did not in any way point to the existence or truthfulness of the allegation. Rather, the Honorable Hindi was seeking for further and better particulars of the allegations, which further and better particulars were not given. As to the alleged transfer from Chireka to Narifenya, my lords, we have checked the lock-up registers of both facilities, and I must state that no person is held at any facility, Chireka, Narufenya, or anywhere.
He's saying they have been released.
Huh?
He's saying they have been released, so if you check...
No, I'm saying we have checked the lock-up registers. Even if a person was to be held for only 5 minutes, his name would be entered on the lock-up register. The lock-up register do not show any entries of any of the alleged persons. And I still insist that the allegation is false.
I think we have listened to counsel, and what is clear is that by
The conduct of counsel, especially counsel for the petitioner, we are being diverted from the important job of inquiring into their petition and spending time on issues that should have been covered by them a long time ago. And court is really very concerned about this. For whatever reason you are doing it, because you had 10 days as the Constitution requires to file your petition. During that time, you knew your case, you knew the evidence you needed, and you stated so when you filed that you have affidavits and a list of names of people being filed in court together with the petition. The petition now has been in court since, I don't know how many days now, 10 days. and there is no sign anywhere of those affidavits on that list. You came up with an amended petition which we allowed. To give latitude to the petition to pursue his matter so that the court can inquire into it, we are still now being treated to left, right, center. We have no way as court of knowing the truth of the allegations. If you had filed the list of people who had deponed affidavits in court, you would now be saying, look at number so and so on that list is detained, because then we would have data to go by. We have nothing, so you can go on claiming that they are so and so and so, but we don't have those people here as you were supposed to do. So there's no way we can know that the people you say were arrested were actually deponents of affidavits. So we think that when counsel come to court, you should, especially on a matter of this importance, you should go an extra mile to be extra serious. And I'm not seeing that seriousness in you at this point in time. However, if anybody is being arrested or harassed in any way, the agencies of government must inquire into that so that whoever is doing that is brought to book. And if any lawyer is being accused of unprofessional conduct, I would ask that the relevant authorities, the Law Society, the Law Council, should take interest, and we will make appropriate recommendations when this matter is done and finished. But for now, let's proceed with the important matter of inquiring into the petition. Yes, we were supposed to be dealing with now the proper pre-hearing in terms of identifying any agreed facts and agreed issues. Perhaps the more correct thing would be to allow counsel consultations among yourselves, and if you can come up with an agreed issues, you call us in and we come back and we settle that. Facts and issues. Well, of course, we assume in the days you have been exchanging these documents, I'm sure each one of you has some issues that have come to mind. And we would rather that you consult among yourselves, then you can let us know. And we, how much time do you think you would need to? 30 minutes. About 30 minutes? Let's give you 1 hour. We'll court will reconvene at midday. We hope you have something in agreed.
petitioner and the respondents have agreed on issues and facts. I'll begin with issues. The agreed issues are: issue number 1, whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commission Act in the conduct of the 2016 presidential election. I repeat, my lords, whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commission Act in the conduct of the 2016 presidential election. Issue number 2, whether the said election was not conducted in compliance with the principles laid down in the provisions of the Presidential Elections Act and the Electoral Commission Act. Issue number 3.
Can you repeat that?
That's obliged, my lord. Whether the said election was not conducted in compliance with the principles laid down in the provisions of the Presidential Elections Act and the Electoral Commission Act. Issue number 3. If issue 1 and or 2 above are answered in the affirmative, whether such a non-compliance affected the result of the presidential election in a substantial manner. I repeat, my lords, if issue 1 and or 2 above are answered in the affirmative, whether such a non-compliance affected the result of the presidential election in a substantial manner. Issue number 4. Whether an offense under the Presidential Elections Act was committed in connection with the election by the first respondent personally or with his knowledge and consent, or approval.
I think you go through that again. You are a bit fast.
Number 4, my lords, whether an offense under the Presidential Elections Act was committed in connection with the election by the first respondent personally or with his knowledge and consent, or approval. Issue number 4. 5. Whether the third respondent, the Attorney General, is properly joined as a party to this petition. I repeat, whether the third respondent, with the Attorney General, is properly joined as a party to this petition. Issue number 6. Whether the petitioner is entitled to any of the reliefs sought. Whether the petitioner is entitled to any of the reliefs sought. My lords, that does for the agreed issues. We now come to agreed facts. My lord, it is agreed, number 1, that there was a presidential election conducted by the second respondent on the 18th February 2016. Number 2, that on the 20th February 2016, the first respondent was declared as validly elected president with 5,000,000 617,503 votes. Representing 60.75% of the valid votes cast. If I may repeat, my lords, that on the 20th February 2016, the first respondent was declared as the validly elected president with 5,617,503 votes, representing 60.75% of the valid votes cast. My lords, the third agreed fact, which is the last, is that on the same day, on the same date,
Be specific.
on the 20th February 2016, the petitioner was declared to have polled 132,574 votes. $132,574 votes, representing 1.43% of the valid votes cast. My lords, counsel for the petitioner has one issue which we did not agree upon, and we leave it to the discretion of the court. I so beg.
My lord, we will seek your guidance. We had an issue, which would be number 6, but it is just proposed. We are seeking for your guidance. Whether the second respondent relied on any results to declare the first respondent. Whether the second respondent relied on any results. Relied. As a basis, on any results, as a basis to declare.
Can you repeat that? I think there was something I'm missing.
Whether the second respondent relied on any results.
On any results?
Yes. Okay.
Yes.
On any results from the polling stations and district tally centers.
From the polling station?
From the polling stations and district tally centers as a basis to declare the first respondent the winner of the 2016 presidential election. Then number 2. Whether the petitioner is entitled to the preliminary relief of vote recount in the areas specified in the petition.
Can you repeat that?
Whether the petitioner is entitled to a preliminary relief of vote recount in the areas specified in the petition.
Is it area or areas?
Areas. The last one is whether there was a national voters register compiled, maintained, and updated by the second respondent during the 2016 presidential elections.
Repeat that.
Whether there was a national voters register compiled, maintained,
No? Maintained.
yes, and updated by the second respondent for the 2016 presidential election. My Lord, we proposed those issues, but they were not agreed. And as the usual practice, we seek your guidance and see whether they can be taken or they can be argued. Yes.
How good?
Yes.
My Lords, we did not agree with these issues because we deemed them superfluous as they are properly addressed under the issues framed and agreed facts. In particular, issue number 1, whether the second respondent relied on any results as a basis on any results from the polling stations and district tally centers as a basis to declare the first respondent the winner of the 2016 election. We have already agreed with the respondents in the facts on the total votes that the first respondent got. Where else could he have got them from?
That is what we're supposed to inquire into.
Now, if the allegation is that these votes were not got from the 30 centers, then the matter will be addressed when we address the issue of non-compliance of the provisions of the Act. So for that matter, we regard it as superfluous. Regarding the petition as issue number 2, whether the petition is entitled to the preliminary relief of vote will count, our view, my lords, is that we don't need to frame that issue because under section 59, subsection 9 of the Presidential Elections Act, subsection 9, no, sorry, 8. The court upon hearing a petition and before coming to a decision, if it is satisfied that a recount is necessary and practical, it may, whether prayed for or not, order a recount of the votes cast. So in our view, raising it as an issue is superfluous. The same issue is repeated under the rules passed by the Chief Justice on the presidential elections, election petition rules 2001, Rule 21, which reads, whereupon hearing a petition and before coming to a decision, the court is satisfied that a recount is necessary and practical, it may order a recount of the votes cast. So this is a matter of law. We don't need to plead it, we don't need to make it an issue. So as such, we regard it as superfluous.
Lords, the issue of whether there was a national voters register compiled, maintained, and updated by the second respondent for the 2016 presidential election is already covered under issue number 1 that has been agreed upon. Whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commissions Act. the conduct of the 2016 because it's an issue of non-compliance that is provided for by the two acts. So we don't need to have it as an additional issue at all.
Yes. My Lords, I associate myself with the submissions of my learned colleagues.
Mr. Mbowes, you want to say anything more? Yes, a short one.
My Lord, maybe I just need to state that one, the issues are the issues we have framed, the ones we have proposed, are really fundamental issues arising from fundamental breaches of the principles of the law. We could equate them to the fact where an election is held without a secret ballot. Of course, there would be no election. So you frame an issue to that effect, whether there was an election.
But if you held an election without a secret ballot, the issue would be whether that complied with the principles of the Constitution and the law.
That would be one, but for purposes of also being systematic, you can say...
that is systematic enough.
You can also say whether there was an election. Anyway, my lords, I'll leave it to your discretion.
Because they have raised the point that these are really things that are covered by the law. For example, on your proposed issue number 2, whether the petitioner is entitled to the preliminary relief of vote counting. Now, the law doesn't give vote counting as a preliminary relief. It may well be what decides the... one of the reliefs which the court can grant is to declare a candidate that was validly elected.
Yes.
If the vote recount shows that it is actually Mr. X, not Mr. Y, the court can say so.
Yes,
and that wouldn't be a preliminary relief.
But
so you're asking for it as a preliminary relief?
From my reading, that's what it's then, 59. From my reading. Whereupon hearing a petition and before coming to a decision, I thought it's the preliminary relief. That's why
before coming to the decision, but it may well be that the decision is what is found by the vote counting, because the law requires that you can declare a person who was validly elected.
Yeah. Well, my lords, on our part, we thought that these are issues which could be included in the framed issues, and we would leave it to your discretion to determine whether they should be passed or not.
All right, this is a decision on the matter. It's the view of the court that the issues as agreed by both parties are sufficient for the determination of the petition for court. The issues suggested by counsel for the petitioner are well covered within the agreed issues. Court is of the view that the agreed issues will enable court to inquire appropriately into the petition. Accordingly, the court endorses the agreed issues as agreed by both sides. So now this settles the facts and the issues. The way forward, we'll stick to the timetable that we agreed on Monday, Yes, on Monday, I think. All filing must be in by close of day Sunday, including the skeleton arguments. Yes.
Yes, my lord, my lord. The interaction before we started the scheduling.
The what?
There was an interaction regarding complaints that we had acted unprofessionally. However, there was an issue that was not covered, and one of them was we were seeking for leave for extension of time within which to file our affidavit evidence.
That I can answer straight away. I don't have the time to give you, because the time we are operating has been set by the Constitution, and today is what's the date today? 11th day. We have just barely 20 days.
Yes.
We have spent all this time in these preliminaries. But we had agreed you can still serve your petition, your affidavits. They should have been served by yesterday.
Yes, my lord.
So you have already given yourselves an extra day. So these affidavits should still be served by close of the day today and served.
Okay.
So that people can then respond to them and write their skeleton arguments. And when you open your case on Monday, because you'll be opening your case on Monday,
yes,
it's up to you to be ready.
Okay, that is one. Then two, there's the issue of documents. My land friend, Mr. Enos Tumusino, has written a letter which is on record.
So on record?
I would assume, because I can see have a stamp. Because we had requested for several documents, they have answered in respect of one set of documents. Yeah. If you read the fourth paragraph, it says, in light of the above, the second respondent would suggest that if it pleases the court, their lordships and the parties meet at the second respondent's premises this Saturday for an inspection of all the required DR forms. Well, the date on our side is really too far if we are going to close, because we are thinking we would have the rejoinder. Our rejoinder is on Sunday. And then two, I don't know that the court is also is acceptable to the proposal to meet at the second respondent's premises, but that is for the discretion of court. But mine was just to ask them to bring the date forward. But that is only in respect of the other forms. Yes. The tally sheets, they have not mentioned anything. And the database information, they have not given us. And if they're giving us Sunday, we will not be able to beat the deadline of Sunday to make a counter or the rejoinder which closes. Then as that is, I just wanted to make all the points and then maybe they can.
Right, Mr. Tumusino.
My Lord, we clearly pointed out that these DR forms will be ready for inspection on Saturday at 2 p.m. Besides that, my Lord, this information was handed over to the petitioner on the 23rd of February 2016.
So that means the information is available.
It's available, but for
He's
the
asking, can it be given
physical inspection, which they seem to be interested in, as they say, if you look at paragraph 37 of the amended petition, they say they already have these documents, but they want to compare with our documents. Now, what they want to compare with was passed on to them in a soft form on the 23rd of February. And the chairman of the Electoral Commission's letter clearly states...
Where are you reading?
Sorry.
Where is that letter of the chairman?
Sorry, it's not yet on record. But we informed court this morning that this information was given to them, and they know it, they cannot deny, which contains the national summary of the final results, the district summary tally sheet, and a soft copy of the tally sheet of results per polling station in this country. Now, if they want to look at the hard copies, that's what we're going to provide on Saturday afternoon. This is, we cannot do it earlier because of the volume of work, but
Actually, I was going to suggest that you do it earlier because we have got other engagements, as I will explain on Saturday.
my Lord, maybe in our communication, which we're going to provide this afternoon, in respect of items Roman 2 and Roman 3, will indicate if it can be done earlier. But the communication from our client was that Saturday afternoon would be the earliest time. We are looking at over 28,000 polling stations. And these results are polling station by polling station. So we've also, in our letter, requested if it's necessary, if court deems it necessary, we'll be compiling over 616 reams of paper, and each ream is 500 pages to bring to court. So I genuinely believe that our client has, in all honesty, put this time of Saturday 2 p.m. to enable the parties to look at. My Lord, we must not forget that today and tomorrow, the second respondent is organizing elections. The electoral process is not yet over. So we are squeezing, and Saturday 2 p.m. is the earliest that we can avail these records.
Obviously the second respondent has his own headaches, and I have my headaches here. We have 2 applications that have been filed by people who want to be amicus curiae in this court, and we are fixing this for hearing on Saturday because we want all this to be out of our way before the hearing starts, and we have a limited period for hearing which is outside my hands. So I do hope that because all these things are with the second respondent, obviously they have that data, they have all that information.
My Lord, just make a correction. The letter that I'm referring to, where the letter of 23rd Feb, the first respondent has attached it to his pleadings. It is Annexure M. It is on page 100. Definitely the petitioner...
Can you first let us get the letter, please?
Yes.
Next year, what?
The first respondent's answer to the amended petition.
First respondent.
And first respondent, Yoweri Kaguta Museveni, on page 100, I believe it's the last annexure. he clearly indicates that the Chairman Electoral Commission forwarded to all the candidates the national summary of the final results, the district summary tally sheet, a soft copy of the tally sheet of results per polling station. So we believe the exercise that the petition is interested in is to cross-check or verify this information against the hard copies that remained at the commission from which this information was extracted. And since they already have it, I believe it will not prejudice them because we are really talking of, it's only tomorrow. On Saturday, 2 o'clock, we'll definitely be ready to provide it. Much obliged.
I think, Mr. Barras, I'm inclined to say have it on Saturday afternoon after we are finished with court here. And if it becomes necessary on Monday, I can extend it time.
That is one, but I think there is a softer way out. If you look at their petition, rather their response, page 12.
Which one?
The newest they have filed. Second respondent's answer to the amended petition. Paragraph 47.
Page what?
Paragraph 47D, page 12 of the affidavit of Engineer Bad Kigun. They say the results were transmitted from the district tally center by scanning a copy of the newly designed declaration of results form, from which data would be captured, tallied, and then transmitted to the National Tally Center.
Which paragraph are you reading?
47?
Of the new
Yes, of the new.
responded answer.
Second respondent's answer to the amended petition.
Page what?
Page 12.
12.
The affidavit, not the answer.
Or the affidavit.
Yeah, the affidavit of engineer.
Yes, so which one?
I was saying, since we can have it electronic, they give us CDs of that, since they say they were uploaded, and that doesn't require paper. I think the most they would need is about a CD, and we also have the tally sheets. The tally sheets they're talking about are the tally sheets online, which are signed by Engineer Badru Kigundu. Everyone, I think, has been seeing them. The tally sheets we are looking for are the ones signed by the district returning officers, because the Engineer Badru Kigundu was not in all the districts. I think this one, the commission knows when you go to section 54 and 56. So the DR forms, I think we can get them electronically as they do. The tally sheets, duly signed by the returning officers. We can also have them. He says he's going to return to us on the BVVK and BVVS, their biometric. And then maybe on Saturday, we could go to see what is in the database. I think that would solve our problem.
My Lord, as we've already pointed out, the petitioner was provided with copies of the tally sheets, and it's clearly indicated in that letter. However, if they're interested in looking at the hard copies, they will also be availed at the time.
Are you interested in the hard copies or the soft copies?
Well, my Lord, it arose because they were telling us Saturday. So I said, we can do electronic. instead of going through the, I think there were there were issues of course. We can have the electronic. If the DR form is scanned, it cannot be changed. We can have it electronic. Similarly, tally sheets.
Although, Mr. Mbabazi, you are not answering the question whether you received what is on record as having been received by the first respondent, because counsel for the commissions did refer us to this letter.
Yes.
And the question is whether you actually received the same letter or an identical letter.
Well, I cannot confirm whether the candidate got it, but if I may answer, we are looking at national summary of final results. That's not what we're looking for. District summary tally sheet, summary tally sheet. We are looking at the tally sheets which are at the district. Then soft copy of the tally sheet of results per polling stations. These ones we have even looked ourselves at online. They are online. They are signed by Badru Kikundu, engineer. Those are not the tally sheets we are looking at. The tally sheets come from the district, signed and witnessed by the agents.
District and the agents.
Yes, those are what we are looking for.
My Lord, if my learned friend is amending his prayer to ask for soft copies, as long as those copies are in the possession of the Commission, we will definitely provide them. And the Commission, the second respondent, has soft copies of the tally sheets, has got soft copies of the DR forms, so we'll provide them once he...
Well, you understood what he's asking for. He says tally sheets signed at the district, and that what you published, what you gave out, were the ones signed by the chairman of the second respondent. I don't understand it. But
My Lord, I believe the petitioner is not following our pleadings. We have indicated that at the district, from the district, that information was transmitted electronically to the National Tally Center. If the petitioner is interested in getting the hard copies that were delivered from polling stations to the district, he should be prepared to wait for the collection of those hard copies from the districts to the second respondent's headquarters.
Are the electronically compiled tally sheets signed by the returning officers?
My Lord, when information is received from the presiding officers at the polling stations, it is received at the district headquarters or the district returning officer's place, where it is scanned, put into an electronic format, and verified or validated, and then is transmitted electronically to the National Tally Center. At that stage of receiving, storing, and validating, the parties who are present sign, and the electoral officer, the officer in charge of that station also signs. So if the petition is prepared to wait, we will collect all these from all the stations.
But Council, wait for what? Today is Thursday. If an order was given by the chairperson who says I want everything by tomorrow, why can't the district returning officers provide those?
Much obliged, my Lord.
Whether hard or whatever.
Yes. If
you see, Mr. Tumsime, if you look at section 56 of the Presidential Elections Act, it could help us. It spells out what the returning officer is supposed to do.
transmitted either with electronically.
If I can read it, each returning officer shall immediately, after the addition of the votes under section 54(1), declare the number of votes obtained by each candidate and also complete a return in the prescribed form indicating the number of votes obtained by each candidate. Then subsection 2, upon completing the return under subsection 1, the returning officer shall transmit to the Commission the following documents. A, the return form. B was repeated. Then C, the tally sheets. And D, the declaration of results forms from which the official addition of the votes was made. So these documents were supposed to have been transmitted to the second respondent. So at least they should be there. I don't know whether these are the documents that Mr. Mbowes is looking for.
Much obliged.
But this is now a matter of what the law requires to have been done. And then if you look at subsection 3, a returning officer shall compile and submit to the Commission within 7 days after the conclusion of the election a report of the election within the returning officer's electoral district. The other ones are supposed to have been sent immediately, then after 7 days you have the report. Now these are documents which obviously should be in the possession of the second respondent.
Much obliged, my lord. I request for some more time to consult my client and write back to court this afternoon, informing court the earliest possible time when these results, rather these records or documents can be availed to the petition.
That should be copied to the council as well.
It's much obliged, my lord.
Yeah, but Mr. Tomasime, for my clarification, because if the district returning officer transmitted, did he transmit the scanned tally sheets which were witnessed, or did he scan and transmit?
My lord, I know for a fact that when those results are received and entered, a form is generated that is signed by all the parties who are present. That is some of them, the candidates, rather the candidates if they are present in those areas, if not, then their agents. But the electoral officer signs on every sheet that is printed out.
Yes, but are those the ones which were transmitted electronically?
That's so, my lord.
And those are so in other words, the electronic copies you have bear the same signatures as the hard copies that you say are at the district.
I'm not exactly sure what was scanned and transmitted. That's why I want to consult my client. I would really not want to put my position in the position of the client. That's why I request to be allowed time.
This time you go and consult, because this is a very important consultation.
Much obliged, my lord.
So, subject to your consultations, the time of 2 o'clock on Saturday still stands.
Much obliged.
Just, my lord, for the record, I seem to have understood that we have been allowed to file our affidavit evidence today.
Yes.
Yes. So I hope my land friends will accept
We have been
service.
allowed to file today.
Yes.
We have bent over backwards. We don't.
Yeah.
Otherwise, if we shout out your affidavits, what happens?
Okay.
So, but please,
Today, my lord, we'll do that.
file them today and serve them,
Yes, my lord.
because our time is running out. If we are to make due inquiry into all these things you are raising,
Yes.
then actually we need much more time than this.
The last one is, when shall we come to the point of naming the persons or applying for leave in respect of witnesses we want to cross-examine? Should it be, I think, at the pre-conferencing, or maybe...
We don't even know who your witnesses are going to be.
Yes.
And you are asking whether we can, because I'm sure even the other side would wish this.
Yes.
They wish. So I think we do that at
On Monday. Thank you, my lord.
My lords, can we be clear with my learned friends as to by what time that they will serve these affidavits today?
I think, as we indicated, it must be by close of business today. I don't want a situation which arose yesterday. I was working late here, and then I was informed that your side had called our staff that you are still bringing things, and they waited until 10 o'clock and there was still nothing. Now, I think we work office hours, surely. So we are not going to have this type of thing.
Yes. My lord, I'm sorry about that. But
so I think by close of business today.
Okay.
We normally close office at 5 o'clock. Yes. We can bear it up to 6 o'clock, but surely beyond 8 is not acceptable.
Thank you, my lord.
Yes, Attorney General.
My Lords, I'm seeking your Lordship's indulgence on a small matter of representation. I stated that the parties was as before. I omitted to mention that the third respondent's team was joined by one Patricia Mutesi, and I pray that she be put on record.
My lord, we also have Honorable Segona, who is also on the team.
Mr. Malazi, I admire your love for the use of the titles Right Honorable and Honorable.
Yes, my lord. But, because I'm not one.
I don't know whether Mr. Segona is even dressed as counsel here.
No, my lord.
So I don't see him.
He's invisible.
Mr. Mbabazi. Mr. Mbabazi? About Right Honorable. Why did you think that that title was necessary in your petition? Because we have no candidate called Right Honorable.
Yes, my lord.
Why did you consider it necessary to add it there? And would you consider removing it?
My lord, if with your guidance we can remove the
guidance.
If we had an opportunity to amend, we would.
All right. So we'll start our hearing on Tuesday. In principle, the petitioner will have 2 days to present their case, and the respondents, because there are 3, will have 3 days. Time permitting, we'll have the last day for submission of each case, and thereafter the court will go into the harder work, looking into the evidence and so on. Tentatively, subject to what happens. 2 days for the petitioner, 3 days for the respondents. That's next week.
Starting Tuesday.
Monday. It said Monday. That was a slip. We'll still start on Monday. Still start on Monday. As I indicated, we've been served with 2 applications by persons who want to be allowed to come in as amicus curiae. We will consider these applications. We have directed the registrar to serve all the parties, and we'll meet here on Saturday, 10 o'clock, to consider those applications. And that means that service must be effected almost immediately, so that any responses, replies, affidavits should be in tomorrow. I'm sorry the timing is not mine, but that's what we have.
Council Nkurunziza, you had, on Monday you had an issue about the registrar's communication about electronic submission of pleadings and other documents.
Yes, my lords. We felt that it should be made clear that upon filing of the electronic pleadings or affidavits, it should be at the same time copied to all the other parties, so that we all have exactly the same document on soft copy, and we can also compare it with the hard copy.
Okay.
Make sure that everything tallies.
Mr. Mbabas, do you have any objection to that?
I'm in complete agreement with.
What about counsel for the other respondents? Electronic submission. It's not supposed to dispense with the filing of hard copies.
File the hard ones.
It's
For
supposed
those of
to
us who
assist.
were born before computer.
Yeah. You have been availed an email address, and we request anything that you file to also submit it electronically and copy to all the parties for, I think, for purposes of our records and to avoid any possible changes in the documents. The document should be the exact document that has been filed in court. Don't amend electronically what you haven't filed. No. Yeah, because that will be that will not be proper on your part, and we hope you will be able to comply with that order.
I think that finishes our business for today. We meet on Saturday, 10 o'clock.